very recently, on the 14th of June 2022, the EDPB has responded to an open letter from a series of NGOs, privacy NGOs, such as NOIB, Bits of Freedom, etc., that were calling upon a structural and procedural enforcement of the GDPR and how the EDPB could help in helping other SAs reaching that goal. And in its response, the EDPB referred to a previous statement that they had done in the context of the Vienna enforcement meeting or conference that was held in April 2022, by highlighting a series of activities that have already taken place or initiatives that were launched in the past year. One of which being the coordinated enforcement framework, but also the support pool of experts. Those are initiatives that really demonstrate what is going on, at least since I joined the Belgian DPA, which is we need to communicate more with each other. And that's really something that I could experience on the first line while working on the IAB Europe case. But going back to the joint agreement letter from Vienna, I think the statement, if you haven't read it, I really encourage you to read that statement, which is pretty short but contains or gives a pretty good view of what is going to happen in the course of the following months. But in my view, this could be boiled down to 3 words. So it's about diversifying the cooperation methods. And so the diversifying aspect, first of all, in my view, tackles or aims to tackle one of the main critics against the one-stop-shop mechanism and procedure, being that the whole process of enforcement is actually centralized into the hands of one LSA. And as a result, as long as the LSA does not act quickly upon it, the whole process is basically stuck. So that's the main critic that we often hear as DPAs, of course. And I think diversifying is a good approach to, or provide a series of remedies against that critic. The reason is that instead of centralizing everything in the hands of one LSA, if we could find a way to distribute the burden of enforcement across different SAs, not only will that improve the way we all work together, but also how we operate on our own territory, because we can learn from other SAs, we can exchange best practices. The pool of experts is also a very good idea because it allows SAs with maybe smaller resources or less resources than other ones to still enforce against big tech companies, which are very rarely simple cases, of course. And so it's really about diversifying how we approach big tech regulation. The second component is the cooperation part. So obviously Article 60 of the GDPR is about cooperation. There are also other provisions, such as the Article 61, which allows for the mutual help or assistance, but also the mutual inspections or investigations, for example. But I think the cooperation part was a key aspect in the IAB Europe case, in the sense that instead of waiting for the draft decision being finalized, so to speak, at the Belgian level, and then only put that draft decision on the IMI system, allowing other SAs to provide comments, to provide reasoned objections, etc., we really focused on discussing early on, at a very early stage of the case, with other SAs, just to exchange views, to maybe have their experience with similar cases on their own territory, for example. And I really believe that this early on conversation or discussions we had, so a lot of informal meetings, calls, exchange of documents, for example, really allowed us, once the draft decision was published, to very quickly clarify any misunderstanding we had. And I also believe that it helped the other colleagues, especially looking at the complexity of the case, to really understand in a very short time frame, which is 30 days basically, to really understand what they were looking at, what the main points were of the decision, the areas where we were maybe less certain of our stance, etc. And so this illustrates again that DPAs, first of all, do collaborate. They do discuss with one another. So this is, I think, one of probably the key defense we have against big tech that are evolving rapidly, by collaborating, by exchanging views, I think this is the only approach basically to be able to enforce against very complex technological cases. And so, of course, in the IAB Europe case specifically, we did receive reasoned objections from 2 SAs, but once again, very quickly, we reached to our phones, we called those SAs, and we managed to actually clarify the objections pretty quickly. So we did amend the final draft decision to some extent to accommodate all the views. And in the end, it was a success because we avoided an Article 65 conflict procedure, which was something we really feared in such a complex case, which basically touched upon residents of the entire European Union. And last word is, of course, methods, so diversifying cooperation methods. And by methods, I really refer to the necessity, of course, as regulating bodies to operate by the rules. So this is, it's a given, first of all, but it's also important to clarify those aspects in the procedural rules or in the procedures, that are still maybe a bit unclear or some grey areas that we want to tackle early on, once again, by ensuring a harmonized approach, by making sure that we all understand, for example, the concept of sharing all relevant information without undue delay. What is relevant? What is information that we can share? What is information we should not share, etc. So by clarifying all these aspects and by developing common methods of working, of enforcing, this is the third component, the third pillar, if you want, to effective enforcement against the major players. And so the Vienna statement, coming back to that, specifically referred to the example of a standard or common complaint forms that could be shared. It's not mandatory, but it could be shared among SAs, again, in order to collect a common set of information common to each and every complaint, which would facilitate once we exchange files. So if, for example, the Belgian gets a complaint, Belgian EPA gets a complaint against, I don't know, an Austrian controller, for example, we would gather sufficient information for the Austrian DPA to be able to enforce swiftly, instead of having a ping-pong of please provide us more information, etc. So, in a nutshell, I think it's really about discussing more, which we are actually doing, despite some critics we might hear from external sources. Also ensuring that we have a common approach. So instead of discussing what differences we have, we are trying to discuss those differences, of course, but also try to reach a consensus and try to reach a common ground, a common way of operating, a common way of enforcing, basically.